Can the estate sell a house right away after someone passes? The short answer, no. The long answer, yes, but only if you know the exact steps. And if you get it wrong, it could delay the sale, cost the estate thousands of dollars, or even trigger a legal mess. So stick with me in this video. I'm going to break it all down for you. My name's Gary DiGrazia Jr. I'm a second-generation probate real estate expert with 20 years of experience helping families just like yours. And I also train other real estate agents on how to efficiently facilitate these complex sales. Even though my YouTube channel is new, you're in the right place for sure. I'm the expert you're looking for. I help families sell homes during probate the right way, and we avoid the costly mistakes that most people and real estate agents commonly make. Today, we're answering the big one. When can the estate actually sell the home during probate? And how can we do it the right way? Probate doesn't start automatically. It begins when someone, usually a family member or nominated executor, files the petition for probate in court using the DE 111 form. From there, you'll be assigned a court date, usually 30 to 60 days out. That's when the judge appoints the personal representative, either the executor if there's a will, or administrator if there's no will. But here's the first curveball. You can't sell anything or even list the home until the court approves the petition and issues something called the certified letters. There's certified letters of administration or testamentary, depending upon the situation. These certified letters give you the authority to act on behalf of the estate. Without them, you're just a well-meaning relative with no legal power. Once you've got those certified letters, you're legally allowed to list the property, prepare it for sale, accept offers, and close the sale. But you can't distribute the funds yet. That comes later. Now, here's where a lot of people, even real estate agents, get this wrong. Even though you can list the home and accept an offer, the sale isn't final until you file the Notice of Proposed Action, also known as the NOPA. This document is sent to all the heirs, and it basically says, hey, we're selling the house for this amount on these terms. If you object, now's your chance. They have 15 days to object. If no one responds, you're good to go. No court hearing required under the IAEA with full authority. If someone does contest, we'll handle it. And a little bit more on that in a minute. Before escrow closes, the title company will request something called the Federal Tax Statement Letter, also known as the Comfort Letter. It's just a fancy way of saying, hey, IRS, we're not accidentally triggering any estate tax issues here, are we? It's another document we handle in collaboration with your legal team. Once that's cleared, the title company has it along with the NOPA and the certified letters. Now we can close the sale. But where does the money go? The proceeds are held in the estate's bank account until final distribution is authorized by the court. But here's the part most people don't know. I've worked with attorneys and private funding sources who can actually advance a portion of the inheritance to the heirs if it's needed. Maybe someone's behind on rent. Maybe you or a family member is living in the estate home and needs some money now to relocate before the home is sold, or in order to sell the home. You don't have to wait 6 to 12 months for court to sign off to access some of the proceeds now, and we can help you with that. Probate homes come with some exemptions for the estate too. You're exempt from several traditional seller disclosures like the transfer disclosure statement, the SPQ, because maybe you haven't lived in the home or you haven't for decades, and even the natural hazard disclosure. Now, the NHD report is still required, but as an estate selling a property, you're exempt from paying for it, and we negotiate to make that a buyer paid item. Also, if the estate home value is below $750,000, you may qualify for an expedited process, but that's something you're going to want to discuss with an attorney. Now back to my job. My job's not just about listing the home. It's about protecting the estate during escrow. Up front, I meet with you and all the heirs to get everybody on the same page, give space for questions and concerns, and reduce the chances of anyone contesting the sale later on. But if someone does object, that's when the court will have to get involved. And at that point, it is what it is. But unlike most real estate agents, I know how to protect the estate and keep your deal alive so you don't end up losing your buyer, or worse, get dragged into a legal mess. I work closely with your attorney to keep everything compliant and transparent. I've put together a probate real estate resource guide for you. You can download it for free. The link is in the description to this video. It will walk you through every step, timelines, and legal documents that you're going to need. If you're in the middle of probate right now, or you're about to be, go ahead and book a free consultation with me. I'll walk you through what to expect, and I'll help you map out the smartest steps moving forward. No pressure, no sales pitch, and no obligation. Just remember, you're not alone in this. So let's do this right together. If this video helped, hit the like button, subscribe for more probate tips, and share this video with your family. It's a great way to keep everybody on the same page. I'm Gary DiGrazia, the pro in probate real estate. Thank you for watching, and I'll see you on the next one.